Hi, I'm Nate Gilbert, attorney in San Antonio, Texas, and today I want to talk about the 3 big mistakes people make when forming their own LLC. You can form your own LLC. We've talked about in other videos. In Texas, you're allowed to do it without an attorney. You do not need an attorney. However, when I get folks that call and say, I've done most of the work myself, I need you to look at it, or can you just check the paperwork and make sure I did it right? Normally I don't do that, but when I do see things like that, these are the big 3 mistakes that I see a lot of times. Number 1 is forming the wrong entity. Okay, sometimes an LLC is not right for you, or sometimes you wanted to file an LLC, but you are meant to file a different kind of LLC. Okay, so if you were starting professional practice and you filed a regular LLC, well, we want to make sure it's a PLLC. Okay, so we want to make sure you have medical malpractice or malpractice in general protection. Second one, like a Series LLC. There's statutorily required language in Texas that must be included in the LLC certificate of formation. There's not a separate formation certificate. You just got to know where to put it and what it has to say. So if you've done that, if you filed and think you have a series or think you have a PLLC, you might not. Additionally, sometimes an LLC is not the right entity. We want to look at partnerships. We want to look at corporations, professional associations, those kind of things. We want to make sure that we're not just starting an LLC because it is the most common. We want to make sure that the LLC actually meets the needs of the business. It serves the purposes that we're trying to achieve and is going to be the right kind of entity for the individuals going forward that are forming this company. So that's kind of the thing we want to make sure of. It's fairly easy to fix. We can reincorporate if we need to. We can file certificates of amendment. Even in the most drastic situations, dissolving and refiling as a different entity or entity type is not the end of the world. It's a little more paperwork. It's going to cost you a little more to undo the mistakes if you hire an attorney to do it. But in the end, we're making those adjustments because it's worth it. The second one is not having an operating agreement. Okay, this is a very, very, very common thing, especially where we're just forming an entity to hold a piece of real estate and we don't really think that we're going to be running businesses through it. If you start a business and you want that limited liability protection, okay, for the limited liability company, and you don't have an operating agreement, you're not getting it. Texas does not require entities or LLCs it does not require LLCs, excuse me, to have an operating agreement. It's not required by law. However, if you get sued, if there's some kind of liability and you do not have an operating agreement and you don't have any corporate governance documents, you're not going to be getting that limited liability protection. Just not going to get it. I can tell you that right now. They're going to do what's called piercing the corporate veil. They're going to get at you personally, attached to your personal assets, wage garnishment, all that sort of stuff that we want to prevent with the LLC in the first place. Very easy solution. We just draft an operating agreement. Okay, we can do an operating agreement very easily, even if your LLC was formed 10 years ago, you haven't done anything with it, you really want to make sure that it's protected, get the operating agreement done. And do not use one that you find online and don't understand. Okay, that's a huge mistake that I see a lot of times. That's, 2A of the mistakes I see is using an operating agreement you don't understand and that wasn't drafted for your business. Third biggest one, too many members. A lot of times people think that everyone who's going to be touching the business needs to be involved as a member. I don't think that's the right way to do it. There are some attorneys that might say that's wrong. Let's get a whole bunch of members in it. Let's get buy-in from a bunch of people to get this business rolling. I'm more of a keep it simple kind of guy. I like to keep things simple for my clients. I like to have businesses be closely held. I don't think that everybody who's going to be involved whatsoever in the business or running the business needs to be a member or a shareholder, and whatever the case may be. I think let's keep it tight, let's keep it secure, and keep it held kind of close to the chest. So when you're forming it, make sure that you understand who's going to be a part of this business, what their roles are going to be, and how you're going to keep certain roles in check, how you're going to keep certain groups of people in check if you need to. So if you don't need to include people that are running the business on the day-to-day in the actual business entity, that may be a course you want to check. But speaking with your attorney, talking with them about what the roles mean, members versus managers. We've talked about in some other videos about what it means to be a member, what it means to be a manager, and how that can play out in real time. So these are the big 3 ones that I see a lot of. If you have questions about your LLC that you formed, or another attorney formed for you, or even your own attorney that you still like, you want to reach out to them and say, hey, I've got questions about this. Did we do this right? Let's make sure that everything is sealed up tight. I get calls from clients all the time asking questions, and I love being able to go through and say, yep, we did it this way. We made sure this was protected and done correctly. So we can alleviate those concerns and make sure that you're on the right track.